Good afternoon, everybody, and welcome to this meeting of the Licensing and Appeals Subcommittee hearing. My name is Luciane Balker. I'm the clerk, helping with the procedures. I'm going to start the meeting by asking the panel to nominate a chair for this meeting, please.
I would like to nominate Councillor Maggette.
Are you all in agreement? Yeah? Okay, Rebecca, over to you.
Thank you, Luciana. I'd just like to introduce us all on the panel here today to start with. My name is Rebecca Margetts. I'm the councillor for Finch Hampstead. Beside me, I have Chris Cook, who's councillor for Westcott. Rachel Lucas, who's our legal advisor here for Woking Borough Council. To my right, we have Kay Gilder, who's Borough Councillor for Southlake, and Luciana, who's already introduced herself. The first thing to say is just to talk about the licensing objectives that we have here today. That the whole purpose of this procedure is we're looking at the prevention of crime and disorder, public safety, the prevention of public nuisance, and the protection of children from harm. Everybody's going to get the opportunity to speak and make their representations today. I'll call each person as it's their turn to speak, and then there will be the opportunity for questions after they've spoken. At the end, there will be the opportunity for the licensee, some sum-ups from the applicant and the licensee, and then the committee will retire to make their decision afterwards in private, and there will be a notification of the result by letter within 5 working days. Okay, so the first thing we're going to go to is the officer report, which is coming from Kieran Hinchcliffe today.
Thank you, Chair. Members are requested to determine the application for a review of a premises licence in accordance with Section 52 of the Licensing Act, having regard to the review application itself, the representations that have since been received during the consultation period, and the requirement to promote the 4 licensing objectives. The purpose of this report is to provide the relevant information for the subcommittee to consider and determine the application from Miss Christina Davies as an other person for the review of a premises licence at Redan 24 Peach Street, Wokingham. In determination of this application, the following options are open to the Licensing and Appeals Subcommittee. You may modify the conditions of the licence permanently or for a period not exceeding 3 months. To exclude a licensable activity from the scope of the licence permanently or for a period not exceeding 3 months. To remove the designated premises supervisor, or DPS. To suspend the licence for a period not exceeding 3 months. To revoke the licence. To issue formal warnings to the DPS and or the premises licence holder, or to take no action. The application itself, it relates to Redan 24 Peach Street. Within the application, at 1.2, it details the licensing activities that are currently authorised for this premises licence. The licence holder is Green King Retailing Limited, and the DPS is Mr. Sagan Gurung. His personal licence is PL 1801, and that's issued by Wokingham Borough Council. The premises licence itself is attached as Appendix A. The application for review of the premises licence that was submitted by Ms. Christina Davies as another person. She is the assistant of Councillor Rachel Burgess, and a copy of this application was sent to the premises licence holder. The grounds for the review relate to the licensing objectives of prevention of crime disorder and the prevention of public nuisance, and the full details of that review are set out within the application and supporting information, and that's attached within Appendix B. The application itself was properly made and all the procedures were correctly followed. Photographs of the blue notices in place are attached as Appendix C. For the consultation, there is a 28-day consultation period. A representation was received from Wokingham Borough Council Environmental Health, and they've detailed an investigation into the complaints received concerning the premises, and a copy of that representation is attached as Appendix D within the report. Additionally, there are 9 representations received from other persons, 5 in support of the review application and 4 against it, and those representations are all included as Appendix E. Those that have made a representation have been informed of the time and date of this licensing and appeals subcommittee hearing and have been informed of their right to attend, and we have attendance today. In terms of the legal considerations, conditions may only be attached to a premises licence where they are deemed appropriate for the promotion of the licensing objectives. They must be proportionate and not duplicate any existing provisions contained in other legislation, and a justification behind a refusal or even the attachment of conditions must be given to the applicant. The subcommittee, in arriving at its decision today, must have regard to the relevant provisions of national guidance and its own statement of licensing policy, and should set out reasons given for any departure. There is a right of appeal to Magistrates' Court within 21 days from the date the applicant is notified of the decision of the licensing subcommittee. That concludes the particulars of the report. I'm happy to take any questions, but your information is all set out within the bundle. Thank you, Chair.
Thank you. Does anybody have any questions? Chris?
So looking at the licence, it was originally granted in November 2005, is that correct?
Yes, so the Licensing Act 2003 came into effect in around then.
Yeah. Has it varied since then? So is what we've got in front of us what it was originally granted as, or has that changed over time?
I believe we've had a full variation application. So at page 12 of the report, it details there's been some variations to the application. So below the signature of the authorised officer, you'll see the original application coming in 2005, and then there's been a change of several changes of DPS, and there's been a minor variation of full variation, which happened in 2015 and 2016. But that is the copy that you have now is the relevant premises licence.
Okay, thank you.
Do we have any other questions? Yeah, right. If I just take one at a time. So if we go to, sorry.
Can I just assist the panel with a question? Sorry, potentially complete curveball, but I just noticed something, Kieran. I'm looking at the licence conditions, page 15 of the bundle, prevention of public nuisance. And it says at C4, all doors and windows to be closed when regulated entertainment is provided except for access and egress. How does that sit? And it may be that you're not best placed to answer this, but how does that sit with the outside area being licensed, if you follow? And that might be something for somebody else to answer later. But I anticipate that the panel will want to address the nuances of that or not, as the case may be.
If I may assist, obviously as the premises licence holder, I can address that question, and if you address it to me as part of my submissions, I'll be delighted to sort of clarify the legal position on that. That might be the easier way.
We will hold that point.
Yeah.
Thank you.
Okay, Kieran, did you have an answer for that, or is that something you're going to come back to us on the point that Rachel's just made? You're going to come back?
I think it would be fair to have our licence holder provide their response,
Okay.
and then we can take.
Right, so I think first was Christina Davis. Did you have a question? Are you okay if I call you Christina? Yeah, if you do. Okay, if you'd like to ask your question first. I'm not sure your microphone's on there.
That's it, got it. Didn't press it hard enough. It's just a little question regarding the witness statement and the 2 representations in favour of the Redden that came in well after the consultation period ended. I understand that a consultation period of 28 days is exactly that. And these have come in well late. That's all I'd like to add.
Okay, can I refer that to Rachel?
Yes, I follow entirely what you're saying. You're saying the response of the manager came in after that period. I have had regard to the Section 182 guidance, which is the guidance which is applied when making licensing decisions. And paragraph 11.15, the last wording of that is it's particularly important the premises licence holder is made fully aware of any representations made in respect to the premises and any evidence supporting the representations, and that the holder or the holder's legal representative has therefore been able to prepare a response. And effectively, my understanding is that the licence holder is entitled to respond to that evidence put forward. And that is that response, the
Yeah.
document.
Licence holder, yes. Representations together with the licence holder, no. Because if that was the case, then obviously several people down Rose Street who are supporting would also have put in late representations.
It's not a representation, though. Those, effectively, the application is bought against
Yeah,
the
and
Redden.
every right to
And it's
respond.
their response to that, and they can't put in the response until they've seen the pack with all the representations. So that's my understanding in respect of that. Effectively, if they hadn't have put it in, they could have come here today and said exactly the same thing as has been put in, and nobody would have had a chance to consider it in advance, and that would have been their right to address this panel this afternoon and read out exactly that. So there is no difference between a response in writing and a response verbally, and I anticipate that you'll be getting both because they are here today to give their response as well. But that's my understanding of the guidance.
Yeah, so I could have bought a couple of other representations after the consultation period.
No, because the period for representations has finished. So, I don't know.
But it clearly says in the witness statement at the bottom. I hear what you're saying, but I'm talking about a consultation period. The licence holder has every right to respond, obviously, but I'm concerned about the 2 extra statements.
I follow, and they won't be taken into account. They can't be taken into account because they're outside the period.
Thank you.
So, sorry, may I just address on that point, because it is a legal point. You're right, Ms Davis, it's not a representation, and it's not counted as a representation. It's evidence in relation to our submissions, and the committee are entitled to give it as much weight as they deem fit. What it means is that those parties are not party to the application per se, so they don't have any rights to appeal or anything like that. They are simply witness statements to our statements, so they're not representations insofar as they have any rights. They're simply evidence we're putting forward to the committee to take into account and give the weight that they might deem it necessary.
I'll come to you now, Mr. Warren, if you have any questions.
It's very rare I ask a question at this stage, actually, but there was one that I thought the licensing officer might be able to assist me with. Obviously, Christina Davis is bringing the application here, and her papers can be found from page 21. There is, however, a representation, and she goes, as she says on page 21, by Tina Davis, as she's just said here. There's a representation at pages 51 and 52 from a Miss T. Davis. Okay.
Sorry, I don't know who she is.
No, I just wanted to clarify. For the purposes here, they were 2 separate individuals from the officer's point of view.
Thank you for the question. They're two separate individuals. I think you made that clear, yeah.
Right, do we have any other questions? Did you want to ask another question, Ms Davis? Could you?
Just one more regarding the representations in favour of the Redden within the consultation period. There was one from a Jack Powell regarding DJ music and DJ being played outdoors, etc. Could I ask the panel to ask the licence holder, is that one of your DJs?
Palmer, Jack Palmer.
Jack Palmer?
Yes,
yeah.
yes it is, yeah.
I thought it was.
Thank you.
Thank you.
Thank you. Right, so the next point we're going to move on to is responsible authorities. And this is where I'll come to you, Mr. Long, who's the Antisocial Behaviour Enforcement Officer and is also from Environmental Health, if I'm correct. Yes.
Yeah, hello. So, yeah, Chris Long from the Antisocial Behaviour Team at Wokingham Borough Council. Part of our role is to investigate statutory nuisance, including noise. So we were made aware of 2 complaints from 2 residents.
Sorry.
Mr. Long, can you hold on one moment?
Is it not
Sorry.
the applicant next that gets to present their case?
Thank you, Councillor Burgess. I was just about to direct.
You can direct who you want to go first.
Yeah, according to our...
Probably a mistake in there because it probably should be the responsible authority.
So it's okay. We handle lots of different applications and review hearings and appeals and so on. So this is a review application. So this is an application being brought. Where there's an application being brought, the correct order should be for the applicant to bring out their application. I think you're once you've heard from the applicant and questions, it then may be the representations. It's unusual because obviously we've had representations from responsible authorities, but the applicant is Ms Davies, represented by Councillor Burgess.
Okay, sorry, I'm just following the agenda I have in front of me. So apologies if we've got a little bit out of order, but I'm sure we can get back in order now. So we're going to go to the applicant now. And is that going to be both yourself and Rachel? Yeah, so we start. If you'd like to go ahead.
I bought the licence review. It's taken a very, very long time to reach this point. I first complained to Wokingham Borough Council around about October time. I spoke to Mr. Chris Long, who assured me of full investigation, basically. It would take a long time, but full investigation. So, as you can see, I've made my summary in my application of the effect that it's had on us residents. There haven't been 2 complaints made to ASB. There were more. There were emails sent as well. And that I would like to obviously hold in question. But I would like to go on to saying not only has it affected us residents far down in Rose Street, which is approximately 200 metres from the back of the Redden, up to last year, I think it was following refurbishment of the Redden. Never a problem, not at all. Mainly indoors, I think. There was the odd occasion of a party night or a disco night where, yes, the music went too far. And I think a brother of mine popped over and said, "Can you turn your bass down, please?" But, oh, well, it's just a party, you know. So that's fair dues. The mental effect has in turn caused physical effects to one of my neighbours at 44 Rose Street, who was suffering from cancer because he's had to put up cardboard soundboarding at his windows. The reason being the music is not a normal DJ type music as we would have known years ago. It's a rave type, hypnotic, euphoria type of music, and it has considerable bass, which travels down Rose Street. The upper end of Rose Street near Broad Street don't seem to be affected. One of my friends lives up there and they said they can't hear it. You've got the Methodist Church, the Bradbury Centre, which obviously is like a sound barrier, but it does hit us down further down Rose Street. My neighbours at 48 Rose Street and in Lisa also made complaint and had a recorded device put in their home. My neighbour, as I said, 44A Rose Street, I think it is, has suffered considerably. My neighbours at 42 Rose Street. My neighbours at 40 Rose Street. My neighbour at 1 Rose Court, and myself, and others, and another, I think, in Dunham Court. The problem we have is that residents in Rose Street are mainly older people and are affected by thudding bass, particularly the rave-type music. And it seems there's a lower threshold for a statutory noise nuisance compliance, which is what Mr. Long investigated for. Public nuisance as a higher, and obviously you've got the licence objectives. You've got the licence objective of public safety, public nuisance, and prevention of crime and disorder. I would now like to add that there was an attack, a very serious attack, on the 31st of May this year. I'm not sure why it's not in the agenda pack, but it was the 31st of May, and the police subsequently advertised for witnesses from the CCTV that they released in the media. I also contacted the police because I pleaded with the antisocial behaviour team that night at 10 past midnight and asked them to urgently attend. They ignored me. I was completely ignored. 40 minutes later, a gentleman suffered very serious injuries from an attack at around 1 o'clock in the morning. I'd then like to say that on the 30th of September, again in the early hours of the morning at the Reedham pub, a gentleman was glassed with a bottle, which led to a charge of grievous bodily harm. I think taking these into account, and also another attack in 2013, it is clearly the early hours that is the issue. I wouldn't want anybody to be deprived of a nice pub. I've been in there. My friends go in there. My neighbours go in there. But the problem is it's after 11 o'clock when this type of music starts, and it's only since last year, since the DJ has been operating from outdoors at the furthest end in Peach Place. And I stipulate outdoors. Where it comes down to public nuisance, obviously, this is what I'm saying regarding after 11 o'clock at night. And also after 11 o'clock at night, from the witness statement, I noticed that Mr. Rogers has said that he is the premier #1 night venue in Wokingham. There are certain laws regarding night venues, nightclubs, and planning permission is a must. And certain other rules, disability, clientele, all sorts of things. It could be where he has stated in his witness statement about a queuing system and other things like he has bouncers, door staff. But the issue is the playing outdoors of the DJ. And also, a license application was made for late night opening from the Leafy Elephant, a gin bar, in Peach Place. And it was made September, October time, 2018. An environmental health officer from the council actually made representation against the late night opening. And the final decision, after a lot of to and fro's and representations, the final decision, at first it was 11 o'clock at night, and then it was 10 o'clock at night, because, quite rightly so, Kate Powell, the environmental health officer, quoted certain conditions in the planning regarding Peach Place and music outdoors, or even music indoors. So the decision was made, and the applicant of Leafy Elephant was informed that 2,200 hours was the decision. Regarding the attack in 2023, 30th of September, I understand, and correct me if I'm wrong in this, there was a review for the license in October 2023. I don't know the outcome of that review, other than that the hours have remained till 2 o'clock in the morning. There's also another premises, Sit and Sip, who are extremely thoughtful of residents. They often have events. They had one on Saturday, which was really good, in the square. Very loud music, but very enjoyable music. And it came all the way down to Rose Court. Every single word could be heard, every musical instrument. But it was good music. Not that I should be biased against rave music. And they finished at 10 o'clock. So I'd like that to be taken into consideration, please, particularly the emails that I have of where Kate Powell, Environmental Health Officer, had conversations with the licence applicant of Leafy Elephant. And those are the main issues. And then I'd like to go on to say about the antisocial behaviour team regarding 6 visits, which they kindly conducted for us from the 2 complaints, but there were more, absolutely were more. And the Office of Clive Jones MP, who has also been involved with myself and Rachel regarding this, asked the ASB to clarify this several times, and they didn't. So of the 6 visits that the antisocial behaviour team made, from a period of 27th of January to the 5th of May this year, I think a 3-month period, there were 29 nights, Friday and Saturday nights. 6 of those were the visits. Each visit, it was absolutely apparent to us residents that they knew they were being monitored. Absolutely, it was quiet, it was just about could hear it, but so what about the other 23 nights that we've had to suffer? Also the previous nights before the monitoring visits, i.e. early January, mid-January, all of December, Christmas Eve. Well, forget it, trying to hear the church bells. That wasn't possible because of the rave-type music, which then went on till 3 o'clock in the morning on Christmas Eve. And what about the other nights, Friday, Saturday nights, where we've had to endure thumping in our homes? I sent in a video that somebody else had taken on the 22nd of February to the ASB team and others, which clearly shows after midnight what is happening at the Reed-End and the music. And it's bad. I'd then like to say that of all the residents in Rose Street that I have spoken to, and there have been many, obviously, to try and get to this date today, many have feared to complain. and would not complain because of that fear, because the licence holder, when he had bar 56 in Rose Street, also caused quite a few issues and very loud music. And again, the antisocial behaviour team, from what I understand, said no statutory noise nuisance. So regarding statutory noise nuisance, that is no longer, in my view, of trying to get the hours reduced to the reasonable hours of Peach Place, because effectively it is Peach Place, to not a full revoke of the licence. That was, yes, I put that in, understandably, because it's been very, very difficult. But I would like the hours reduced to what is compliant with Peach Place and the planning documentation that I've got and the documentation of Kate Powell, Environmental Health Officer. This is not a nightclub, and should not be called a late night venue either, or après nights. It is severely affecting us residents. So I can only hope that you will take this into consideration. I have full evidence of the emails that I have spoken about, the video, and everything else. And I also would like to bring into the representation of Jack Palmer, who made representation, not saying that he was the DJ, who I have come across, I have attended myself, I have asked them continuously up until about February to turn the bass down. Very, very bad. I categorically say that I did not abuse staff. And in September, October time, I had a broken elbow, which was in a protective sling, which was manhandled by one of the bouncers or door staff, if you like, when I went over and said, please turn the bass down. This was about 1 o'clock in the morning. Also, my brother went over on another period of time. And again, this business of working with the applicant is non-existent, absolutely non-existent. The way that I was manhandled on my broken elbow caused me to ring the police. And they asked me if I would like to place a charge of assault. And I said, all I'm asking is, I'm actually ex-police myself. And I know that police cannot get involved with rowdy music, blah, blah, blah. Only public order situations. And they said, in which case we can't get involved. You need to involve the council. But regarding the manhandling of your broken elbow, would you like to place an assault? He asked me again, and I said no. I said, I will follow procedure, correct procedure, and I will go through the antisocial behaviour team. The antisocial behaviour team should be representing residents, as well as venue licence holders, but putting residents really first and foremost with regard to the licence objectives.
Okay, thank you. Rachel, would you like to say something?
Yeah, thank you, Chair. Just a couple of brief points to add based on, to add to what Christina said. So, to put it simply, no other venue in town, as I understand it, is allowed to play music outdoors until 2 a.m. No other venue has that. So, I mean, personally, you can see in the pack that Woking Town Council have said that they can't see a reason why it would be different in the case of the Redan, and I would be in agreement with that, and particularly actually with the other venues in Peach Place, which, as we've heard, it's now very much a part of. Other venues in the town, Red Lion, Den 42, similar types of venues have similar hours for music, but that's indoors only. So it does seem unusual that that the licence allows outdoor music to 2 a.m. Obviously, we heard about the Leafy Elephant example too. Secondly, just to briefly touch, I know we're going to hear from the other responsible authorities shortly. We've heard that in the pack it does state the ASB team have not been able to prove a statutory noise nuisance, but just to be clear that my understanding is that relevant to this application is obviously public nuisance under the Licensing Act, which is a lower bar in terms of judgment. So I would ask the panel to consider, obviously taking in the evidence into account as regards the statutory noise nuisance and the evidence there, but to consider whether there is actually a public nuisance, particularly in relation to the late night noise outside. I mean, finally, no one would expect, and Christina won't expect, to live in the middle of a town centre like Wokingham and not have some noise and some, it's not going to be peace and quiet in a town like Wokingham, but it just does seem unusual that these particular licensing conditions are allowed for this one venue, and obviously I've heard from my residents as to kind of the detriment or knock-on effect on them. Thank you.
Thank you, Rachel. Are there any questions that the panel would like to ask to the applicant, Kay?
Christina, could you tell me how long you've actually lived in Peach Street?
I actually live in Rose Court.
Rose Court, sorry.
And I'm very proud to live in the cottage that my mother, Anne Davis, who was a leading public figure in Wokingham. When she died, I was very fortunate to be able to buy my brothers out to move into the cottage. It's a beautiful court, and we all look after our properties very well indeed.
What year was that you moved in?
Oh, sorry.
What year was that you moved in?
I moved in April 2019.
Uh-huh.
My mother died September the 4th, 2018.
All right. There are another question I'd like to ask. You say about the incidences that the police have been called out to, attacks. Have they been taking place at the
Reading,
premises?
yes.
They were actually in the premises?
In the early hours, yes.
So why aren't the police here today then to actually tell us about them?
Precisely.
Sorry, yeah.
To assist the panel. To assist the panel, as part of the statutory consultation, Thames Valley Police are a consultee, so they have the ability to make representation, and if they wish, they could have brought some information around whatever incidents have been recorded with the premises. During that consultation period, we received a response from the police that they would not file a representation. So we've had confirmation of receipt through the statutory process and confirmation that they wouldn't make representations. So we don't have that information on the crime disorder aspects from the responsible authority.
So they don't actually feel that there is any problem with crime and disorder in that area at all?
With how our representations not been made, we can't presume. We can't question them on that. In terms of ourselves as licensing officers, there have been incidents, and we have met with the premises and discussed some of their security provisions. But we in terms of this consultation, we don't have any further information from the police.
I wanted to ask a question just to clarify. So you've lived there since 2019, and this has become a problem, it appears, in approximately the last 12 months. Yeah. So before
Sorry, since the refurbishment.
Okay. So before then, it had been manageable. You feel
Manageable.
the noise, and this has only really become an acute problem within the last 12 months.
Yes, because the DJ is outdoors. and in Peach Place. It's an extension of Peach Place, that can't be denied. It's made to look like an indoor area, but it isn't.
Okay, thank you.
I do understand that soundproofing has been put in, but to no avail to date.
Okay, thank you. Do we have any other questions?
I have no questions, thank you, Chair.
No. Can I just check with Luciana the procedure now? Who am I calling next? So we're now going to go to the... Sorry, you wanted to ask something, sorry.
Yes. Regarding the police incidents, they have been put in the media by the police asking for witnesses and stipulating exactly what went on with those 2 attacks. Thank you.
I am aware of them. I have seen them, so thank you. Right, so we're now going to go to Chris, second time lucky. If you'd like to make your representation or your comments, thank you.
Hello, yes, I'm Chris Long from the ASB team. As I said previously, we also deal with statutory nuisance investigations, and that includes noise. So in relation to the read-down, we received directly into the ASB inbox 2 complaints from residents regarding noise emanating from the premises, specifically amplified sound and particularly the sound of bass from the sound system. These complaints were followed up and they were investigated as a possible statutory noise nuisance. So if it helps at all, in the pack there is a map of where the read-down is in relation to the complainant's addresses. So the investigation, we followed our standard protocol, so that consisted of noise diary sheets which we give to the complainants, asking them to record and detail exactly when the nuisance occurs, the frequency, and also the effect it's having upon them. These investigations are carried out according to our training and according to our understanding of the Environmental Protection Act 1990. As is standard protocol, we inform the subject of a complaint that a complaint has been received and that they will be investigated for a noise nuisance. We're also aware of our duty within the town to liaise with publicans in respect of public nuisance and to try and mitigate complaints and to try and address these. So with this in mind, I visited the read-down to inform them that a noise complaint had been received. I met with the manager. He showed me around the premise. He showed me some of the mitigation measures they'd put in place. Some of these included a noise reduction boards, which apparently specifically reduce bass. A picture of one of these is attached in your pack. The management also showed me their diary book. They conduct their own noise level checks in the vicinity, and recorded in the book are the locations these checks are conducted. The licensee was not informed of the dates when officers conduct monitoring or of the times when noise monitoring equipment will be utilised. They're just informed that a complaint's been received and they're under investigation. The monitoring visits were based upon the returned noise diary sheets. We received the sheets, we assessed the data, and based upon that data, we conduct the visits to be timed around the highest frequency. These visits were conducted between the 27th of the 1st of this year and the 12th of the 5th of this year. The visits were conducted between 2100 hours and 0200 hours. To further ensure objectivity, 5 separate officers conducted noise monitoring visits and gave their objective assessment of the noise as they were hearing it. All officers reported that they did not believe the noise, including the bass, as heard at the complainant's location in the court and in the road, was an actionable statutory noise nuisance. During these observations, staff were also asked to make any general observations in relation to public nuisance. No officers recorded any events or any incidents in their pocket notebooks during these monitoring visits. We also additionally on the 9th of May, employed a noise recording equipment at a complainant's address on Rose Street. This machine is self-activated, so the complainant will be able to activate it themselves when they hear what they think may be some noise nuisance. This was installed for a 7-day period. I then recovered this equipment, downloaded the findings, and assessed what had been recorded. My assessment from listening to the recordings during this time was that the noise was also not a statutory noise nuisance. The residents were then informed of our findings.
Thank you. Does anybody have any questions for Chris? Anybody on the panel? The one question I'd like to ask, you're right if I call you Chris, sorry.
Of course.
There seems to be a disparity from what you're saying about the amount of complaints that have been made and what the applicant is saying. Can you give us an explanation at all for that?
Yes, so sometimes people will, they may say to a resident, I'm going to complain to the council, but actually it just doesn't come through to our inbox. We also receive complaints, as you may know, people complain to councillors or to MPs' caseworkers, but that detail doesn't come through to us. So in terms of people that directly complain to us, it's 2 complainants.
Did you have a question, Christina? Yeah,
I do.
Yeah, okay. Go
I've
on,
seen
Ed.
the emails that have gone through. I've seen particularly number 1 Rose Court, next door to me.
Was that to ourselves or a caseworker?
It was to yourselves. Sorry, if I might add, I have already stressed the fear of people complaining. Please take that into account. Thank you.
Yeah, I can't answer for 1 Rose Street. I did look at our database before coming out today, and 2 complaints are logged. So
Okay, thank
I'd
you.
have to investigate further.
Thank you. Are there any other questions? Thank you.
Chair,
Yes.
just one quick question, really, for clarification for Mr. Long. Obviously, you've talked about recordings and observations from a period between January and May this year, and then recording equipment from the 9th of May for a 7-day period. So we're looking up to about the 16th of May, your observations here. That's quite a long time before the committee, so it might assist the committee if you have any further observations since those visits that you might be able to assist the committee with, whether there are any observations you or your officers have made since that period.
Yes, so obviously, when any complaints are received, we will continue to keep an open mind and we'll always assess that noise. Further monitoring visits have been conducted in recent weekends, on 3 subsequent weekends, and still the evidence or the opinion of those officers is it does not meet the threshold of an actionable statutory noise nuisance.
Thank you. Would you turn your microphone off? Thank you. Okay, so the next part is we're going to go to the licensee, and I think that'll be you, Mr. Warren, who'll be making the representation.
Yes,
Thank you.
and if I can just introduce who I have here, Andy Rogers effectively is the operator of the premises, and I have Rachel Smith from Green King as well here. It's probably worth stating that although Green King's name and sign appear above the door, this is a leased premises, so effectively it's not managed directly by Green King, so it's not the whole of Green King here today effectively. This is Andy's business that he runs and operates himself, and Green King hold the premises license for technical licensing reasons that I don't think this committee need really to know about, but go back to 2005, a determination was made to hold the licenses. So we are talking about an individual's business here rather than Green King, but we're all here today to make the same point, so I'm speaking for Andy and Green King here. I always find it slightly disconcerting seeing my face on a screen behind officers as I speak, and I'm starting to think I'll need to get hair and makeup before I do these hearings, because they all seem to be on YouTube nowadays, so makes me feel like a second-rate newsreader. Anyway, look, let's start with some context and basic principles here. I think it's really important that we do so. This is a public nuisance review. There have been some allegations, and certainly some more made today that weren't in the papers, that creep into crime and disorder. But there's no evidence to support those. Councillor, you're aware, obviously, from newspaper reports of things that have gone on in the past. The reality is, however, it's how those incidents are managed that is the compelling factor rather than incidents, because incidents will always happen at premises. And 3 incidents have been referenced in a significant number of year period, which is not, frankly, a lot of incidents. It's worth reminding you as well that at paragraph 2.1 of the guidance for your legal officer, if you want to refer to it, has the following observation. Licensing authorities should look to the police as the main source of advice on crime and disorder, and they should seek to involve the local community safety partnership. So the police are the experts here on crime and disorder, and you can bet your bottom dollar if they felt that Redan was an issue in terms of crime at the premises, they would either be here today or they could have bought their own review. So in terms of crime and disorder, unless you want me to make any comments about specific incidents, which obviously you could ask any questions about, I intend to just focus on public nuisance, which is, as you've heard from Ms Davis, the primary reason why we're here today. So unless you want me to address crime and disorder, I'll just crack on with public nuisance, shall I? Public nuisance is not a number of different things. It's not any noise that someone might find annoying, for obvious reasons. People have different thresholds and different sensitivities. So we're not just looking at the fact that there may be some noise here, and that noise in and of itself is a public nuisance. There is a much higher threshold than that. Secondly, this is not a private nuisance. Now, private nuisance is a different kind of legal nuisance which affects a single property, and that's a civil action. Now, the reason I mention that is because public nuisance has got a very legalistic and long-winded test to it, but in essence what it is that there has to be a effect on a class in society that brings it up to the public nuisance threshold. Now here you'll have seen in the papers and in the submissions by various parties there is a difference of opinion as to what that threshold is, and some people seem to feel there's no issues whatsoever, and some people seem to feel that there are. So we have a class here that are actually at odds as to what the reality is, which is quite an important point, because you have to think of the class as a whole. Secondly, paragraph 9.12 of the guidance, and I'm going to refer to a few bits of guidance, and I apologise for doing this in some detail, but it's crucial to how we make determinations here. Paragraph 9.12 at page 77 of the latest version of the guidance, again, just to help your legal officer if you want to go back and reflect on this, states each responsible authority will be an expert in their respective field, and in some cases it is likely that a particular responsible authority will be the licensing authority's main source of advice in relation to a particular licensing objective. Clearly, your environmental protection team are the main source of advice for matters of public nuisance or any form of nuisance. Thirdly, and this is going to be important as we go through the papers and submission, at paragraph 9.43, the authority's determination should be evidence-based, justified for being appropriate for the promotion of the licensing objectives and proportionate to what it's intended to achieve. So here, we have to look at the evidence before you, and you have to grade the evidence, and you have to give it the weight that you deem is fit for it, but it has to be based on evidence. And that is a matter that's actually reflected in your own policy at paragraph 22.5, where it says the council will expect anybody requesting a review to produce evidence to support their allegations. So that's how compelling it is that this is evidence-based. As such, if we're looking at evidence, the evidence from your environmental protection team, as the experts in the field, I submit should be given significant weight in this matter. Now, there might be some dispute about how many times people have written in and complained, but actually that doesn't get over the point that on 6 occasions, 5 different officers have gone out without warning the premises and have found no nuisance. And they say statutory nuisance, but they also mention public nuisance as well in the papers from the Environmental Protection Officer. And if we have a quick look at pages 33 and 34, Mr. Long's gone through his papers. I don't intend to obviously repeat what's been said, but at pages 33 and 34, it's worth just looking at the timeline. so that then when I come on to what we've done here, and in particular Andy and his team have done, it all makes sense. We have 2 complaints, we think, around January time. The premises is therefore notified, as you've heard, and the premises then takes action, and I'll come on to what action is taken in a moment. The monitoring is then done secretly and without the knowledge of the operators, and then there are also, as you will see, devices put in, or a device put in a premises, and there's a photo of that as well. So I think, you know, the environmental protection officers have gone out of their way to try and assess and properly evaluate what is being heard and what level it has to be ascribed. And they don't think it comes to a threshold of a public nuisance or a statutory nuisance. You've heard there have been more tests since then in recent weeks, and in fact, those haven't received any, reached the threshold. So what we have here, therefore, is a situation where actually the evidence before you demonstrates no public nuisance. And they also go on to say they no other issues as well, I mean, which is quite a compelling factor in terms of the management of the premises itself. You've also heard, and this was the point that actually Ms. Davis made, which is quite, I think, compelling in and of itself, is your officers aren't exactly slow in coming forward when they want to make an objection to a premises license. They will do so, and they will fight their corner to get hours reduced. So it's not like anyone could argue that actually they tend to prefer one side to the other. They make a genuine assessment, and they come to you with what they find. And why are there no findings of public nuisance? Because Andy and his team really do take their responsibilities very seriously. You've seen in the supplemental pack Andy's statement. I'm sure you've read it, so I won't go through it, apart from to draw out maybe a couple of points that I think are very relevant after what we've heard today. He's been there since 2006, so he's been there 19 years, which is pretty good for running a premises in this day and age. And there aren't many people who could say they're the longest, well, there's only one person who could say they're the longest serving person in Wokingham, and he had that title some years back. It's a difficult industry. Forget COVID being difficult, it's very difficult now. And I think it's to be commended that someone has invested into this premises, including an investment last year of £40,000, which is a significant investment. 13 staff, 5 door supervisors at times, and DJs, so there is actually a significant contribution to Wokingham's economy here. And at paragraph 15, we can see the measures that were in place beforehand, and we can work down where we got to. So prior to the complaints from the Environmental Protection Officer at the start of 2025, noise checks were being carried out anyway, which was required under the licence. They then started doing noise monitoring on a decibel reader as well in November, so they were doing that themselves. They have very close liaison with their DJs, and you'll see how that's been developed as well to make sure the levels are kept to something they find satisfactory. We then have environmental protection saying, look, people are starting to complain about the bass noise here. What are you going to do about it? You know, we will come out and monitor, but we'd expect you to take some action. And immediately, DJs are asked to consider how they play their songs. Bass is reduced. A tagline, vibes not volume. Sounds like a small thing, but it's really important because it sets a tone for how people operate. DJs are and will be affected by the management telling them what they do. I can say that with some confidence because I used to be a DJ. And I DJ'd green rooms for the National Theatre, where if you put the volume up at all so that anyone's conversation was unheard, you got a strict telling off. The way you do it is set by the people above you. You'll see here that there were WhatsApp groups set up with the DJs so that everyone got reminders all the time as to how the noise was going. Sound reduction foam was put up in February 2025, so purchased and put up. And since the recordings, and I know you've heard, or you've seen one video, I understand, which is from February, which is the latest evidence you have, if you like, supporting the review. Bass absorption plates have been used for speakers, and indeed the speakers have been changed at a cost of nearly £1,300 to smaller, more directional and better speakers for the area. So a lot of work has gone in to improving what was already considered to be not a public nuisance at the premises. You'll see the two emails that have been appended to Andy's statement. It's worth addressing the point here. Those aren't representations. One person said they had a bit of difficulty actually getting to the council. There are people who came forward to Andy and said, look, we'd like to have our voices heard if we can. You're allowed to give them the weight that you consider as appropriate, given they're not representations, and obviously we wouldn't have them here. They're not here to speak, so they should be given as much weight as you see fit. But one of the residents you'll see of the two actually is the closest, directly opposite on Rose Street from the back of the Redan. So if you have a look at what they have to say, you will get an impression from, if you like, the nearest place from the applicant here. And you'll also see representations in support, and you'll give those the same weight or as much weight as you would the ones against, I presume, in terms of when you come to making your deliberations, so I won't take you through those. Paragraph 17 of Andy's statement makes it clear that there are discussions that the DPS, who I'm afraid, and apologies, can't be here, he's in Norway, couldn't change his trip. He has lots of discussions, obviously, with residents around the area. Andy does as well, in terms of knowing different people who live around the area. So they do try and make sure that they understand what their neighbours think and believe is going on. And if they're satisfied and the EH is satisfied, then the premises is satisfied they're doing the right thing. There seems to be a willingness, I'm afraid, to just assume the Redan is responsible for every bit of music noise in the area. And there are examples of this. So Ms. Boyle, in her supporting representation at pages 48 and 49, complains of pulsating music at 2:30 a.m. on a Monday. Now, we could presume that is a Monday morning from a Sunday night, or it could be, let's even say, a Monday night's trade going into Tuesday morning. Irrespective, it doesn't matter. The Redan doesn't have music outside on Sundays or Mondays, and they close the garden, I think it's 11, isn't it? So that is not from this premises, and yet it sits here in the papers as a statement of fact. It's from the Redan. Indeed, there was a comment made, actually, about music at 3 a.m. on Christmas Eve, I think, by Ms. Davis. The premises shut at 2. Now, we're not here to accuse any other premises of having late nights, but there is a premises that has DJ music, that has bass music, if you like, if you want to call it that, and it can be heard out on the streets. We know because we do sound checks. We're not here, obviously, to, dob anyone in, because obviously the officers, if they were asked to go out and check, would go and check and see if they thought their levels were right. But simply stating 2:30 a.m. on a Monday, the Redan must have been responsible. 3 a.m. on Christmas Eve, the Redan must have been responsible, I'm afraid demonstrates a pattern of behaviour that the Redan gets a bit of the blame for things that simply cannot be their responsibility. There has been some talk about discussions between Ms. Davis and members of staff and door staff at the Redan. Out of politeness, and we are on, I don't know how many people who watch YouTube licensing hearings, apart from a couple of my colleagues, to laugh at the way I conduct myself at these things. Out of politeness, we haven't put in the statement a version of events about how those interactions actually might be. We just want very carefully you to understand that Andy, in his statement, has said that there are times where perhaps staff have felt that Ms. Davis has overstepped the mark in terms of going from polite conversation into something more challenging. I don't know about this single incident that was mentioned, but I think it's fair enough to say that there will be different views on those interactions. But the only person actually that Andy or his team has had direct complaints from is the applicant here today. None of the other parties have come to the Redan directly or complained, and I don't think even Councillor Burgess has raised it with the Redan directly. So she's not come to investigate, what maybe other people think as well. So the best evidence here, I'm afraid, we have to come back to is from your Environmental Protection Officer. If that doesn't go far enough, we've offered 3 conditions. You'll see in Andy's statement at the back of it, so page 8 of your supplemental bundle, there's 3 conditions at paragraph 31. The queue management one addresses specifically an issue that came up from another T. Davis, who put in a representation, who said She had a bit of concern about queues. Now, we don't think they block the pavement. It's a slightly narrow pavement, but actually it's good practice anyway, so we've offered that. A noise management policy builds on the other conditions on the licence anyway, and indeed closing the rear gates to the garden at midnight just means that there can be no to and fro from the back towards the residents. So we think those are appropriate and proportionate measures given the nature of what we've heard today, the evidence that's before you today, to actually deal with the review here. And there's copies of the draft policies and the current dispersal policy in the pack, just for your information. So you'll have seen those. So for these reasons, and I am wrapping up, I promise, paragraph 9.2 at 12, as I've referred to before, the experts are here in the room and you've heard their evidence today. I submit that should be given significant weight. Paragraph 9.43 in conjunction with 22.5 of your own policy is about the evidence. So given what we have here, the latest evidence supporting the review is from February 2025, which is the video you heard. Nothing since then. You have evidence from your environmental protection officers that go up to very recent times and 3 recent observations in 3 weekends. My submission, therefore, is there is no public nuisance here that's been evidenced associated with the Redan or the use of the external area to warrant any action except for adding those 3 conditions. I know that seems, you know, I'm sort of putting my foot on the, you know, putting my foot down here a little bit as a solicitor, but that is based on the evidence, which is what we have to consider. I'll leave it there and I'd invite you to ask any questions you may have.
Right, does anybody on the panel have any questions? I know shall I go first? Yeah. One thing I wanted to ask is, you mentioned that a significant investment was made a year ago to the premises, and this does seem that this is something that has occurred over the last year. Something has changed at the pub in what you're doing, which is whatever you want to say, whether it is a public nuisance or not, officially not a public nuisance, something has changed in the premises to bring these complaints forward, because there haven't been these complaints before, and it's just that you mentioned there was this significant investment a year ago. So what has changed? That because these complaints have come from somewhere. You know, there is obviously something going on that has changed and causing the public to be concerned.
Yes, so if you like, the investment in the premises predicated building the business, including a decision to try having some music outside, which actually, because of the nature of the premises, if you know the Redan, it's kind of lots of nooks and crannies and the bar sort of sits around the middle. It's very difficult to put on music inside without causing lots of pinch points, and actually it caused more complaints than it was worth. So actually the refurb and the investment was to allow for this kind of thing, which is why it's so important to the Redan to be able to have music outside within the public nuisance, you know, clearly without undermining the public nuisance objective. But that effectively was predicated. So last summer, yes, there was more music outside, and clearly that has caused some issues. One wouldn't expect there not to be some teething problems, I think it's fair to say. And as you'll have seen, that there were measures in place beforehand, and when the environmental protection officers got involved, we've done everything to proactively work with them to actually make sure that they are below any threshold. So yes, there was a change at that point, and we're not hiding that in any way whatsoever. But I think that and the observation that the Redan seems to get a bit of stick for matters that clearly aren't to do with them, and given our working with the environmental protection officers, I think our view is we do everything we can, and will continue to work proactively. And if the officers ever find any public nuisance, they can bring a review.
So I just wanted to ask another question. We'll do the panel first, and then we'll come to you afterwards.
Yeah.
Do you mind turning your microphone off for the moment, and then I'll come back to you? Okay. The other thing I wanted to ask was about supervision of the DJs. Maybe Andy can answer this, or if you want to answer on his behalf. You're not there 24/7. You're not going to be there every single night. So how can you make sure that the DJs are supervised? They are individuals. They're going to, you know, they're artists as such, aren't they? And they're going to want to showcase their music. And unfortunately, you will get people that maybe do not follow your standards. So how do you make sure that is supervised?
We have a very tight-knit group of specific DJs, which are handpicked. The professional DJs, they're not, you know, Dave the DJ who goes and does the whatever pub in wherever. The other reason, obviously, is because my number two, the DPS, he's there every single Friday and Saturday night. So he is, he's my right arm. I'm in direct contact with the DJs pretty much 7 days a week. I mean, we're organising things, we're reminding them it's vibes, not volume, every single day that we speak to each other. And, it's become a bit of almost like a sort of a joke, but it's kind of like if you can't hear the customers speak, then you're too loud. And, we monitor this along with not only the DPS, but the head doorman, who is there every Friday and every Saturday. He's responsible for doing all the checks. And if they don't meet our recommendations, then obviously they're told to turn it down. So.
Kay, did you have a question?
Is there anything that you feel that you can do anything more to mitigate the noise problem?
So I think we have. Unfortunately, all of the reports gone up to sort of June. Since June, we've installed the new speakers. So the new speakers now, when Christina's talking about the bass, the new speakers that we've actually got are so good that the bass is now turned like so far down that it's even at the point that we're practically not using these speakers at all, as in the bass speakers. It's that good. So yeah, we have actually we've gone to the nth degree. And if there's anything further, I mean, I've said it to Chris, to everyone, if there's anything further that we can do, I'm not shy of investing a little bit more into getting this right, because it's, happy town, happy bar. It's a very simple thing.
Sorry, I just go to Rachel, and then we will come to you, Christina.
Through you, Chair, just revisiting the point from earlier, because I'm sure you'll want clarity on this. So the current licence condition requiring all windows and doors to be closed when regulated entertainment is provided, except for access and egress, appears at first blush to be in conflict with the outside being a licensed area. So I don't know if you can explain that.
Yes, and the easiest way to explain it is that they're not read in conjunction with each other. Doors and windows to be closed is a condition that says doors and windows must be closed when there's regulated entertainment, irrespective actually of where it's inside or outside. So that would affect any entertainment inside, obviously, where you would have potentially, if they could have done music inside to a larger degree, much higher volumes by closing the doors and windows. So that's what that condition is there for. That sits totally separately to the license which permits recorded music externally. There has been no allegations of breaches of their premises license per se. So you have to read them separately. I mean, the other way of reading it is you could have music outside, but you still have to shut the doors and windows to the building, which sort of, is a bit of a silly reading. But the idea is actually that those conditions, read them separately. The condition in relation to recorded music permits them to have music outside. The condition in relation to doors and windows, by its very nature, is about volumes from inside and preventing those getting out.
So those conditions were in place when we used to do live band music. So obviously guitar music, drums, things like that that was very intrusive. So we put that onto our license just to sort of make sure that we sort of headed that one off at the pass. So that's where that one would have come from.
I will come to you in a minute. Sorry, just quickly going to hear from Kieran. Did you want to say something? And then I promise we'll be coming to you, Christina.
Thank you for your patience. It's just a question on the premises license. If you wouldn't mind, the license summary is at page 16 of your report. I think it would be helpful if we all might turn to the page. I'm grateful for the information that's been sent over, and I think that's quite useful for the panel in terms of the information that you've been provided with is an outlay of how the premises is currently run and currently managed. And it talks about terminal hours, it talks about the hours for recorded music, talks about the hours that they're closing, talks about sort of winding up time in terms of when the premises will close and when they'll stop selling alcohol and so on. It may be useful it may be useful here to reflect that on the actual premises license, because the premises license summary, it's almost at odds with itself. if you look to the opening hours of the premises, it indicates similar times that are being open in terms of the information that you've just been provided by the applicant. So Monday to Thursday up to 1 a.m. and at the Friday and Saturday much later. And then on the Sunday, as we've heard and was pointed out to us, is a much earlier time of 11:30 at night. But if we go to the licensable activities, if you scroll to the next page, it'll be page 17, but I've just gone too far myself, so if you give me a second to catch up, you'll find that the recorded music and also the following page for supply of alcohol, it actually lists until 2 a.m. The majority of the week. And that comes across as though it's misadministration on the actual premises license summary itself, but also is in contrast with how the premises is actually being operated, that it's not being operated until 2 a.m. all the way through the week. Just to raise that to your own attention, and I suppose the question would be is to the license holder if it's comfortable to update the license with the hours that you've supplied. Thank you.
Yes, I mean, what I would suggest, and it makes a whole heap of sense to use this time to do it, and sorry, I hadn't picked up on this, otherwise maybe I would have mentioned it. Recorded music to stop at the same time as the opening hours of the premises, or at the latest 2 o'clock, because there's opening hours for 2:30 on the Friday and Saturday, and alcohol likewise to finish 30 minutes before the terminal hour, i.e. the closing hour. So that would be 12:30 during the week, 2 o'clock at weekends, which it actually is, but reducing those hours, and then Sunday as is would make sense, and we would have no objection to that. So effectively, that would mean that the recorded music hours, Monday to Thursday, go down to 1 a.m. Friday and Saturday stay as is, and Sunday stays as is, and then alcohol, you'd be looking at 12:30 Monday to Thursday, 2 as is Friday and Saturday, and Sunday to stay as is, if that makes sense. And yeah, I think that's a perfectly sensible suggestion to clarify the license.
Thank you. We're going to go to Christina because she's been waiting patiently. If you'd like to have any questions you have.
Yeah, regarding the statement given by Mr. Rogers, sideman. Regarding of course, this is circumstantial. Regarding the representation from Carol in Dunham Court for the review, Carol's a pretty intelligent lady, as I am. And we do investigate where sounds come from. And categorically, it has been the Redan. Unfortunately, Carol didn't video that Monday night, but it was Monday night till 2:30 in the morning. Categorically. I heard it, and I just thought, what the heck? I was in the mode of feeling very disappointed with the ASB team regarding their findings, and the fact that the venue was somehow tipped off to monitoring because there was significant low noise on those visits. I'd also like to say that the gates, when they're closed, makes no difference at the back to sound, as per my video on the 22nd of February proved. The gates were closed in that video.
Christina, can I ask you, because you got the opportunity to make a sum up at the end. Do you have any actual questions for the licensee? Because this is what we're doing at the moment.
Yeah, I hear what you're saying, yeah. Regarding the going to make possible adjustments to the license or whatever and keep the hours in the morning. Then what are you going to do to mitigate what we have been through in the last year, full stop. You say that I don't have evidence. Actually, I do. I've got the emails from Kate Powell, Environmental Health Officer. I've got everything that is needed for evidence. So I'd really like you to clarify that. What are you going to do to mitigate the misery that we're going through when I am on a shift on a Saturday morning or a Sunday morning, working for the NHS that I'm very proud to do so in a senior capacity? What are you going to do, because that affects my patients that I visit in the community? What are you going to do to mitigate this misery if you want the licence to continue to 2 o'clock in the morning? However, of course, no other business in Peach Place has a licence as such.
I can address the points that I can discern as questions in the round, if that would help.
Yeah.
Try and sort of anticipate what the questions are. Well, in terms of mitigating noise nuisance, we will continue to work with the Environmental Protection Officer, and as you've heard, Andy will invest if necessary if there are any issues. Secondly, they were not tipped off, categorically not tipped off about noise reports. But even if they were, it demonstrates that the levels can be played at a level that even the resident here making an application for a review deemed to be an acceptable level. So we're not talking about there can be no levels. There was an acceptable level. They've been having those nights. And candidly, we wouldn't know what those nights are. They're still not in the papers. When the officers came around and observed things, those were the levels. If the officers found them to be too loud, they can come and tell us. We're more than happy to work with them on that basis. Thirdly, categorically, we're closed on a Monday. And I'm afraid the applicant here has just said, I didn't get up, so I didn't check it was the Redan. So there's no evidence from her. And I'm afraid we don't have Carol Boyle here, and I'm not impugning anyone's intelligence, but we have to go on the evidence. And again, if there had been a complaint on the Monday morning about noise at 1:30 in the morning, which would have been perfectly legitimate, the environmental health team would have been round to check that, wouldn't they?
Okay, thank you. Are there any other questions for the licensee that anybody has before we move on? No? So what I'm going to do now is ask you to sum up. Christina, if you'd like to sum up first, and then the licensee, you will have the opportunity to sum up afterwards.
Thank you. Yes, in summary, I believe very strongly that the Reden should not have this licence at 2 o'clock in the morning because no other premise in Peach Place operating outdoors has such. It then becomes favourable in favour of the Reden. And as I said before, there is documentation regarding Peach Place, regarding residents, regarding planning permission, stipulating 2,200 hours for outdoors. So I just ask the panel, please, if you allow Mr. Rogers to continue with this licence, then it would be bias. Leafy Elephant has sadly gone out of business. They really wanted late night opening. They couldn't get it. And it was mainly on the grounds of the evidence from the Environmental Health Officer, Kate Powell, from the council. So that is basically the underlining, and the fact that public nuisance, a statutory noise level regarding the evidence from Mr. Long, then that is at a lower level for compliance. I'd then like to just add a couple more things, if I may. And that is the security manager that I've always dealt with at the Reden has always been extremely pleasant. I think I mentioned that in my application. And he also said that he has considerable problem with the DJ and the owner. He pleads with them to turn it down, and they don't. Yes, you can meet the bar level for bass on the particular technology readings. But regarding public nuisance, as I said, statutory noise is a lower level. And also, I might say that this T. Davis, who I do not know, which incredibly has the same spelling as my surname as well, also stated in her representation about vomit in the streets. There are very drunk people leaving the Redan, banging on the bars of the properties opposite, 2:30 in the morning. People running over somebody's car at number 42 Rose Street, leaving trainer imprints on the roof and a dent. And the police suggested she made a crime report. She did not. There's an awful lot of fear from the residents, because they're in the older category, to make any complaints. But the basis of this is I am asking for consideration to follow the guidelines of the council regarding Peach Place. And I am asking for 2,200 hours cut-off time. I repeat, this is not a nightclub or a night venue. If it is, they need planning permission. They need certain other rules to follow. And that's what I'd like to underline. How can you allow one and not the others? Thank you.
Rachel.
Thank you. Just a couple more brief points. The representative from the licence holder repeatedly said there is no evidence, which to me seems to be very dismissive of Tina's representation and the representations of other of my residents that you've got in the pack. I'm sure you've read them, but you've got one that said they'd lived in Wokingham since 1960s and they're likely to leave because of this noise use, just to give an example. So we can't dismiss those representations and just say that there is no evidence. But yeah, I would just maintain it just seems unreasonable to have a music licence outdoors till 2 a.m. at the weekends, given its proximity to residential properties, Peach Place, Peach Street, Rose Street, and when you take that, those representations of residents into account. And as Tina said, I think we should be using the other premises around Peach Place as a guide for the licensing conditions. I don't understand why the Redan is different to those. Thank you.
We're now going to go to the... Sorry. Okay, we'll go to you two if you've got anything you'd like to sum up.
It was really said, really, because ours is evidence of fact, really, just given the details of our investigation. All I would say is, categorically, we don't inform a subject that we're going to do monitoring. We want to experience that noise as it's being heard by the resident. And if the threshold is met, we would serve an abatement notice, and we have done on commercial premises. We will continue to monitor all of the late night venues in town, all businesses. If there's evidence of statutory nuisance, we would take enforcement action.
Thank you. We're going to go to the licensee now. Could I just ask something before we go to you summing up? How would the licensee feel about potentially reducing the hours of late night music
Outside.
to an earlier level?
I will address that in my summing up, actually, if I
Because
may.
whether that could be something that could be looked at, reducing the hours outside.
Yeah, I will address that. I mean, the reality is they only have music outside on Friday and Saturday nights. They don't have
But
it
still,
outside, apart from
if
background
we're
during
looking
the
at
week.
a way, this obviously has become an issue in the last year.
I appreciate that.
So if there is a way that we can look at reducing these hours outside, and that way that there could be a workable way of moving forward.
I'll try and address that in my summing up,
okay.
if I may. Let me just start by making a quick observation. Councillor Burgess, as she said herself, did not approach the Redan to get a balanced view on what residents think. And had she have done so, we could have introduced her to a number of residents who have very, very different views of the Redan. Might have been helpful from her point of view. Secondly, the premises does have this licence. It's been granted by a committee that considered the nature of it and determined that they could grant it. You'll have seen that one of the residents, in fact, Miss T. Davis, the other T. Davis, mentions the agent of change principle in her review, which means if you move to a noise nuisance, you shouldn't complain about the noise nuisance. Now, there are some changes here as to what's gone on at the premises, but the premises has this licence and had this licence for a significant number of years. And that, as you know, is a property right under the Human Rights Act to have peaceful enjoyment of their licence. It is not enough, and I can't stress this enough, to say that other people don't have it, therefore they should lose it, as a means of taking away someone's property rights. So those are just some observations from some comments that came up earlier. A further one, introducing at the last minute allegations that people from the Redan are walking over someone's car some way away from the premises where it's out of the view of the premises. I'm afraid that is not evidence, and probably I'm afraid another example of an assumption that it must be the Redan that's causing ills. So I'm afraid these things do need to be taken with a pinch of salt. I'll remind the committee, obviously, of the relevance of the guidance and the policy points I've drawn your attention to a number of times. I don't need to do it again. I want to remind you of the 6 separate visits at noise-sensitive times by expert officers, including at 2 a.m, who found no evidence of public nuisance. And since those visits, there's been more works done, and they've gone back and they can't find any public nuisance. We have stressed here in public we will work with those officers, we'll work with anyone who reasonably wants to come and make observations or complaints. We've had no complaints directly from other residents apart from the applicant here before you today, so we weren't aware of any of these people's points of view, and we'd happily take those into account if people did want to come and talk to the premises. And I'm sorry, this notion that everyone is scared of the Redan, first of all, it doesn't comport with Ms. Davis's own opinion, which is actually the head doorman's very helpful. Candidly, he does not have the view that everyone at the pub is working against him to try and get noise the right way. I've said there's been a difference of opinion in how those meetings are approached. Let's leave it at that. I don't think there's any evidential value in us going any further with that. We didn't just rest on our laurels when the EHO officer came round and said, you've had a couple of complaints in January. We put in place measures immediately. We invested in further measures, including, as you've heard, new speakers that mean actually that the base bins are effectively turned off. And paragraph 9.44 of the guidance says this: the authority should aim to consider the potential burden that any condition would impose on the premises licence holder, such as the financial burden due to restrictions on licensable activities. So you are allowed to take into account, and should, in my submission, take into account, the likely financial burdens of reducing the hours, which is something you've asked me to specifically address. So let's specifically address it. When a review comes in, you will not be surprised to hear that Greene King's first thought is, how can we work with all parties, including our tenants, to come to a happy compromise where we can? One of those points, and a significant point, is what effect would it have on the business as a continuing operation? You've already heard what potentially the refusal of a license for later hours did to another premises in the immediate vicinity. These things can't be looked at in isolation. You can't just say, well, a couple of hours off the live music outside, well, it's only, people will still come, it doesn't matter. They have very significant effects on people's use of premises. And we know because we've done it without music. So we know what the effects are. We know how this has helped the business in very straightening times. And the truth is this: customers may look to go elsewhere, and that's not just within Wokingham, that's to Reading and other places. You'll see that in the representations from people who come specifically to the Redan because it is something different, something unique, something that actually they feel safe and comfortable at. Secondly, those that do come are likely to leave earlier. Now, where are they going to go? Well, probably the Red Lion down the road if they leave a bit later, which is already next to some of the residents, and already, I'm afraid, is a premises that has loud bass music that can be heard outside. Now, what you're doing is effectively shuffling people from one place to another where there might be extra problems. So it can have a knock-on effect that way as well. So not only would you actually then, by reducing the hours here, mean that staff would probably have fewer hours, door staff would probably have to be pulled back. I'm not going to say to you the business would close down next week if you did this. I mean, clearly, you know, you'd have to assess what happened, but it will have a very significant financial effect in a time where I'm a trustee of the BII, the British Institute of Innkeeping. They have 13,000 members, 80% of whom have said they won't make a profit this year. That's how difficult times are for pubs and for venues like this. So any little thing you do to change the license might seem like it wouldn't affect the business per se, but it can have a significant knock-on effect. Every penny, it is important to a business like this. But ultimately, let's leave that all to one side. The committee should remember, of course, in my respectful submission, that the only thing that matters is, does the evidence show a public nuisance? What the evidence shows is no public nuisance and a difference in opinion between residents as to what noise is tolerable and what is not. The evidence you have before you from the review is from February, January and February. January and February is not June and July, when we've got new speakers, new monitors, and a willingness to keep working and putting effort in place to make sure there is no public nuisance. Now, as I say, if we'd heard from lots of residents saying you've got to turn this down, it is a cacophony, we don't like it. It would have behoved Andy and his team to do something like that. When the EH officer is saying the levels are all right, when you've got residents that they talk to who live in the area, including the nearest one to them on Rose Street, saying, I don't have a problem with anything you're doing, they can justifiably say, we've done everything and taken into account all the information we have before us to make sure the levels are okay. So yes, it is later than other premises, but that is not a reason to reduce hours. You won't be granting hours to everyone else by keeping the hours here. Everyone would have to come before you and make a submission and a case as to why they should get any later hours, like anyone else. And the officers have already given you the evidence, if you like, that they will fight that where they think it's necessary and appropriate to do so. So I'm afraid we cannot offer earlier hours here, and we've agonised about this. What we can offer is the 3 extra conditions and monitoring, and a very sincere offer to work with everyone going forward and see how this works with the new speakers and all these new measures. And if at that point there is any issue, the officers will be back, the residents can come back, but we believe that actually there is nothing here that would suggest that they're not promoting the objectives. Those are my submissions today. As I say, we've thought long and hard and agonised over what we could offer to try and have a compromise. But it is the Friday and Saturday nights only where we have this music outside. That is, beyond background music. You've heard the premises closes earlier on most nights than its licensing hours in any event. So we have to cut our cloth to when people want to come out and enjoy the premises. So my submission is that on the promotion of the licensing objectives, there is no reason to reduce the hours here. The addition of the 3 conditions, in fact, is probably the appropriate, responsible point. I could have said to you, if you look at the list on page 1 of your report, it says one of the actions you can take is do nothing. You know, and if we'd have been obstinate about it, we could have sat here and said that, but we haven't. We've tried to work very hard to come to what we think is an appropriate suggestion, and those are my submissions.
Thank you. So I think that brings this hearing to a close. The committee will now retire to make a decision, and you will be informed of the decision in 5 working days. But that closes this meeting. Sorry. Quickly, yeah.
So we keep talking about Peach Place and licensing. The license for the premises, 24 Peach Street. We are not licensing. We don't have a license for Peach Place.
We know.
So we close when they close.
We appreciate that.
So yeah.
But thank you. Thanks. So we're going to bring this meeting to a close. So thank you everyone for attending today and for your time. Thank you.